You may be seated. Good morning.
Good morning.
I will be presiding this morning over oral argument, and I'd like to introduce the panel. To my right, I've got Justice Brissett. To my left, Justice McCray, and we welcome you to the Fourth Court this morning. I will call the case at this time. 425-534 CV, Vishal, Nemarugommula, MD versus VHS San Antonio Partners, LLC. I will take announcements at this time.
Good morning, Your Honor. This is Zach Thomas for the appellant, Dr. Vishal.
Good morning, Your Honor. Amanda Hobbs on behalf of Baptist Medical Center.
Thank you. You will each have 20 minutes, and then Mr. Thomas, you will have 10 minutes for rebuttal.
Thank you.
You may proceed.
May it please the court. My name is Zach Thomas, and I represent the appellant, Dr. Vishal. The issue before the court is whether the trial court abused its discretion by denying Dr. Vishal's application for a temporary injunction. This court should reverse the trial court's decision and remand with instructions to enter a temporary injunction in Dr. Vishal's favor. Before I get into the details of why Dr. Vishal is entitled to a temporary injunction, I think it's important to look at the big picture of what is at stake here. All Dr. Vishal is asking is to preserve the status quo, to prevent Baptist Medical Center from making an adverse report against him with the National Practitioner Data Bank and the Texas Medical Board while his underlying claims against the hospital remain pending.
That's the question. Are you alleging ultimately that if Dr. Vishal, I'm glad we're calling him Dr. Vishal today,
Yes.
If he succeeds below, does the fair hearing panel review never get communicated to anyone? Does it go away?
If he ultimately prevails, that would be correct. It would not get communicated to anyone.
Based on what claim? How are you setting it aside?
Well, we're alleging that the peer review process is malicious, and so it would, essentially undo the peer review process that resulted in the 45-day suspension that currently is reportable to the National Practitioner Data Bank.
Okay.
So all he's asking is to preserve the status quo, and it's undisputed that if an adverse NPDB or Texas Medical Board report is made against him, it will irreparably harm his career. That's basically undisputed. I mean, he testified in the trial court at the TI hearing that such a report would have a detrimental effect on his career. That testimony was unrefuted. We also cited multiple cases finding essentially that an NPDB report is per se harmful to a physician's reputation, career, and ability to make a living. For example, in Walker v. Memorial Health System, the United States District Court for the Eastern District of Texas found, among other things, that an NPDB report is, quote, intrinsically harmful to a physician's practice, professional reputation, and livelihood. And it's a bell that cannot be unrung.
Mr. Thomas, I don't think they're contesting that issue, are they? I didn't find that.
They're not. That's my understanding, is that they are not contesting the irreparable harm issue. And so unless the panel has any questions on irreparable harm, I can move on. The next step in the analysis, he needed to show three things to be entitled to injunctive relief: irreparable harm, a valid cause of action, and a probable right to recovery. So we talked about irreparable harm. The next one is a valid cause of action, and this is one that Baptist is disputing, but quite frankly, I think is pretty darn clear.
But don't we get to immunity first? Don't we first have to say that there's malice here and therefore there is a cause of actions due accrue?
Yes, Justice Brissett. So we do need malice to overcome immunity. That is correct. Under Texas Occupations.
Tell me how you overcome 161.010 of the Texas Occupations Code to say that there's malice in this case.
Sure. So this kind of goes hand in hand with probable right to relief, with that factor in the injunctive relief analysis. So, the main cause of action that we're alleging here is malicious peer review. And within that cause of action, there are three elements that the hospital is contesting: lack of probable cause, malice, and that the underlying action did not terminate in Dr. Vishal's favor. So if we can prove malice, if we can show that there's at least some evidence that tends to sustain malice, then it's our contention that we've overcome that immunity bar. It's a qualified immunity, not an absolute immunity. So if we can overcome, if we can show malice, then we've overcome that qualified immunity bar, and we've also met one of the elements of malicious peer review.
And so how do you believe we should define malice under 161.010?
Sure. So I'm glad you asked that, because I think malice is one of these things that we as lawyers, and I think a lot of judges, a lot of times think of malice as like this. We almost have this visceral reaction when we hear the word malice, and we think that it's almost like this impossible standard to meet. You almost have to have a smoking gun to be able to prove malice. But when you look at the case law, that's not exactly right. The case law makes it pretty darn clear that typically malice is proven by circumstantial evidence, not direct evidence. Malice really means a reckless disregard for the rights of the person. It doesn't mean that you have hate in your heart. It doesn't mean that you intended to do them harm. It doesn't mean that you had ill will. It just means that you recklessly disregarded their rights. And so that's the standard.
But Mr. Thomas, the Texas Supreme Court in Romero versus KPH Council Consolidated, I guess, in Texas, 2005, noted it was in dicta because it had been amended after the time of consideration for that case. But it noted that in relation to malicious credentialing under 161.010, that they believe the proper definition of malice going forward would be a specific intent by the defendant to cause substantial injury or harm to the claimant, eliminating the alternative definition of conscious indifference. Do you not believe that's the standard?
No, Justice Brissett. I mean, we would put forth the definition from the Pisciarati case, the 13th Court of Appeals decision that we cited in our briefing. I think that case is more on point than the Romero case because, as you mentioned, Romero is a malicious credentialing case, whereas Pisciarati is really more on point to these facts. It's
what did the court in Pisciarati, what do they rely upon for the definition of malice? Where do they get it?
I'm not sure exactly what the source was, but my understanding is that they said that the definition was reckless disregard for the rights of the physician.
So Romero, the Texas Supreme Court in Romero is specifically talking about the definition of malice to be applied when determining whether there's immunity under 161.010. Was Pisciarati talking about immunity under that code?
Well, I mean, Pisciarati.
And isn't Pisciarati a TCPA case?
It is a TCPA case. I mean, so it didn't, specifically deal with immunity, but it talked a lot about malice, and I think malice is really the same, whether you're dealing with, whether you're looking at it in the context of immunity or whether you're looking at it in the context of one of the elements of malicious peer review. I mean, I don't know why
the Texas Supreme Court's definition was actually adopted by Fort Worth in 2006. So can you tell me why we should follow Pisciarati on that issue versus Kennard and Romero?
Well, I mean, I think Pisciarati is just the most factually analogous case to this one. It's the only one of those cases that's truly a malicious peer review case, which is exactly what we have here.
Okay. Under Kennard, they were specifically talking about malice from evidence that members of a review board did not conduct an adequate investigation and had ulterior motives for denying his privileges. So Kennard does seem to be similar to what happened here. They denied his privileges. But what the Kennard court held was mere evidence of ulterior motive was not sufficient. What evidence do you have that goes beyond just the fact that there might have been a conflict?
Quite a bit, Your Honor. So I would say that we have at least 5 different, what I would call 5 independent pieces of evidence that support malice and lack of probable cause in this case. The first one is the fact that the hospital's own fair hearing panel found that none of the 3 grounds for the MEB's, the Medical Executive Board's decision to revoke Dr. Vishal's privileges was supported. It specifically found, this is the hospital's own fair hearing panel, so it's their words, found that the MAB's revocation of his privileges was not supported, that revocation was not an appropriate remedy, and that he should be reinstated to the hospital's medical staff. So I think...
Well, I agree with you, they didn't like the remedy.
Sure.
But they did not find the allegations unsupported. Isn't that right?
No, I mean, that's a direct quote. I mean, they said the three grounds on which the MEB's decision was based were not supported, quote, not supported.
They actually found that he did access records inappropriately, and they actually found that there were issues with rounding, but there was also policy issues with the hospital. I mean, they did suspend his privileges. They didn't find that the allegations were unsupported by evidence.
Well, I think it's important to draw a distinction between, so the patient access issue on which the suspension is based is actually a fourth allegation that was never raised at the MEB level. It was raised.
The medical executive board never considered those allegations.
That's correct.
HIPAA violations.
That's correct. The fair hearing panel specifically.
So if we take that out of the mix, did the fair hearing panel say that the medical executive board's determinations were unsupported?
Yes. Yes, so there were three grounds on which the medical executive board's decision was based. All three of those were found to be not supported by the fair hearing panel. The fair hearing panel did suspend him instead of revoke his privileges, so they reinstated him, but then they found that he should have been suspended for 45 days based on a fourth allegation, which was the improper access to patient records. And that allegation was never raised at the MEB level. It was raised for the first time at the fair hearing panel level. And we take issue with that because, I mean, for a lot of reasons. Most importantly, the hospital's own bylaws lay out a very specific system for reporting allegations against a physician, having those allegations investigated by the medical executive committee. And it's only if the medical executive committee investigates and sustains the allegations and decides to take action against the physician that lasts for more than 29 days that you even have a right to a fair hearing. In this case, the medical executive board never considered that patient access issue and certainly never made any sort of determination that he should be suspended for more than 29 days based on that allegation.
But I want to go back to definition of malice and what evidence you have of malice, whether you can satisfy the other claim elements of malicious prosecution or malicious review is a different question because you have to show malice.
Yes.
And what I see in the fair hearing panel's decision regarding the conflict, first, I want you to tell me what evidence beyond the fact that there may be a conflict, the fact that they acted in furtherance of that conflict. Because what the fair hearing panel said was there is no evidence to indicate whether it impacted Dr. Vishal's due process rights. We find that the presence of at least two direct competitors in the MEC meeting discussing the recommendation to suspend his privileges was inappropriate, but they found there was no evidence that that conflict impacted his due process rights. So what evidence do you have that they actually acted in furtherance of that conflict?
Well, I mean, I think there's several things. So first of all, you've got these competitors sitting on the board, deciding his fate, voting to completely revoke his privileges, take the ultimate action that they could have taken. And then the fair hearing panel, after reviewing the evidence, finds that all three grounds were completely unsupported. And so I think that combined with the fact that you've got competitors, at least is some evidence to support a lack of probable cause and malice. In addition to that, you've got, it's our contention that they flipped the burden of proof on him at the fair hearing level. As I stated, the fourth allegation, the one on which the suspension is based, was never raised at the lower level. It was raised for the first time at the fair hearing. And under their own bylaws, the burden of proof is supposed to be on the provider only if there was an adverse, only if the provider is challenging an adverse action or recommendation. That's in the bylaws at section 11.7.2. Well, here, as I mentioned, it's undisputed that the MEB revoked Dr. Vishal's privileges based on 3 different grounds, not the patient access issue that was ultimately sustained. And so there was never any adverse action or recommendation based on the improper access to patient records allegation for Dr. Vishal to challenge at the fair hearing. And so because that was raised for the first time, the burden of proof should not have been on him to disprove that allegation. It should have been on the hospital to sustain it. And it's undisputed that the fair hearing panel placed the burden of proof on Dr. Vishal, and that the hospital did not affirmatively prove that he improperly accessed the patient records on which they sustained that 45-day suspension.
And you're saying that that's some evidence of malice when combined with other evidence?
Yes, I mean,
How
there's.
is that malice? How is that malice that they shifted the burden of proof?
Well, I think when we look at that reckless disregard for his rights standard, I think that's a reckless disregard for his rights.
You also agree it's malice under Romero, which is a specific intent to cause significant injury to the defendant, to the plaintiff?
I think it does rise to that level because, I mean, the burden of proof is so fundamental. And I think that when you look at the fair hearing panel's decision, I think if the burden of proof had been applied correctly, if it had been placed on the hospital instead of on Dr. Vishal, I think the outcome very likely would have been different because, the fair hearing panel specifically found that, there was basically nothing more than, the quote was, Baptist could only, quote, speculate about the reason for access.
But Mr. Thomas, I'm a little concerned about your position on that because basically you're saying if a court of law that abuses its discretion and gets the law wrong, it must have malice. We make mistakes, right? But that doesn't mean we're acting with malice. So what case are you relying upon to say that the kind of evidence that you have is sufficient to satisfy the malice requirement?
Well, Your Honor, there's really not a whole lot of case law specifically in this area, so it's a little bit difficult to point to a specific case. But I think we have to step back and we have to look at what was the standard for entering a temporary injunction? Because again, this is just a temporary injunction. This is not ultimately deciding the case. So all Dr. Vishal needed was some evidence to sustain malice. That's it.
That's all we're asking you for.
Yes, some evidence, and I think. This is, pre-discovery. This is at the temporary injunction stage. We've got competitors sitting on the MEB. We've got the 3 original findings completely unsupported. We've got them flipping the burden of proof on him. We've got them raising an allegation for the first time at the fair hearing level that was never properly investigated by the medical executive board in accordance with their own bylaws. All of this comes from them. It comes from their own fair hearing panel report. It comes from their own bylaws. So all of this evidence is undisputable.
Would you agree that it has to be evidence that would tend to prove malice, not evidence that might get you sort of down that path? It has to be evidence that will actually lead to a malice finding, right? Mm-hmm. And that's what I keep going back to Kennard, which says mere evidence of an ulterior motive is not sufficient to establish intent or malice. And so it feels like that's what you're relying upon. In fact, that there's competitors on the panel and they went against him. So I'm asking you, what is the other evidence?
And just so you know, you've got just a little over 2 minutes left.
Thank you, Justice Rios.
Is there any circumstantial evidence of malice?
Well, I think all of this, when you take it as a whole, I think it is malice. Going to your Kennard analysis, Justice Brissett. I think we do have more than mere, competitor. We have competitors on the board, so we do have that ulterior motive. But then we also have all of these other things. We have flipping the burden. We have raising new allegations for the first time at the fair hearing level. We have failure to follow their own bylaws. We have completely unsupported allegations. So I don't think it's fair to say that all we have is, like an inference of ulterior motive. I think we actually have direct competitors sitting on this board deciding his fate. The fair hearing panel hearing officer specifically found that that was inappropriate and may have influenced the decision. And so I think that alone would have merited starting over. Let's start the MEB process over with a fresh panel without direct competitors. But instead, they charged ahead. They completely revoked his privileges, and they charged ahead. And I think all of that taken as a whole is certainly at least some evidence to support malice.
So let me ask you one more question, because we are running out of time. If we get past immunity and we go to whether there's a malicious review claim, and say we adopt Pisciarati and we say it's similar to a malicious prosecution claim, how do you get past the element of malicious prosecution that requires him to be exonerated? And I understand you're arguing to a certain extent, well, some of the claims were thrown out, but he was not fully exonerated. Isn't malicious prosecution for those situations where you are fully exonerated?
No. So we cited the United States Supreme Court in City of Napoleon. It's a 2024 decision that specifically found that one unsupported charge is enough, even if joined with other supported charges. So in that case, they had a meritless money laundering case joined with two misdemeanors that were found to be supported, and the Supreme Court found that one meritless money laundering charge was enough for the defendant in that case to go forward on a malicious prosecution claim against the investigating officers.
And I can understand your point that if three of the four were found to be unsupported, then he's gone at least 2 years with a business that was decimated. I get that. So it seems like you're relying upon us reading the fair hearing panel in the same way you do, that he was exonerated on those other three allegations.
Yes, and I think he absolutely was, because his privileges were completely revoked, and they said that was unsupported and not proper, and he should be reinstated to the medical staff. I think that is an absolute victory on those three original allegations.
Thank you.
Thank you.
Your time is up for now, Mr.
Thank you very
Thomas.
much.
You will have 10 minutes after service.
Thank you, Your Honors, and may it please the court. I am going to jump straight to the Pisciarati case on this because
It's Pisciarati, we've been saying it.
I say it like Mr. Thomas said.
whichever way. But I want to answer some questions here that I heard posed. Now, I'd like to talk about the Pisciarati case in terms of it being an isolated appellate decision that their case entirely rests on. And specifically, this came out of the Corpus Christi Court of Appeals as a memorandum opinion. And the most remarkable thing about Pisciarati is it bears absolutely no resemblance whatsoever to any of the other Texas peer review related case law. And there's a good reason for that. As noted in the court's opinion, none of the briefing pointed the court to any of the other Texas peer review related case law. This decision was made in a vacuum based on out-of-state law from California, New Jersey, Rhode Island, anywhere but Texas. Based on all of this out-of-state law, they concluded that a malicious prosecution claim could arise from peer review. Based on that, or following that, they relied on guardianship proceedings, a car repo case, to determine the standards of proof for this peer review matter. And in doing so, they confused a really complicated issue, which was what standard of malice applies to peer review. Now, we have two competing definitions of malice in Texas with respect to peer review, the Agbor standard and the Maywall standard. As noted by Justice Brissett, the Agbor standard, which I believe was also associated with the KPH case, has been used by the Texas Supreme Court with respect to negligent credentialing claims, where a patient sues a hospital saying that the doctor that provided care to them was incompetent and shouldn't have been granted privileges. Meanwhile, the Maywall standard has been consistently applied by appellate courts both before and after these Texas Supreme Court cases in cases like this, where a doctor is suing because an action was taken against his privileges.
So you're saying Maywall is the definition?
I honestly am not particularly invested in which definition the court goes with here. It could be one of the two, but as we learned from the Ching case, it's definitely one of those two. And
So what about, because after
Sure.
Ching, we had Romero, and then it was adopted by Kennard, where they specifically pointed to the definition of malice in the Civil Practice and Remedies Code 41.0017, which is very different than either Maywall or Agbor.
That one was I believe, that one was the Agbor standard.
Well, Agbor cited Channing v. Jones and defined malice as a reckless disregard for the rights of others. And in Romero, they said that's not the standard, that going forward, it would be the specific intent by the defendant to cause substantial injury or harm to the claimant, and that was adopted after the Supreme Court, Romero and Kennard.
With respect to the recovery of exemplary damages, that particular standard?
That
Yes.
was the standard they used relating to the malice issue.
Okay, yes, and that is the standard to which I'm referring. I'm sorry if I referred to the wrong case here. So we understand that it's one of two of these definitions, either the statutory definition that's used for the recovery of exemplary damages, or the Maywall standard, which has typically been used in employer-employee defamation cases. However, the Pucciarotti case throws in a third definition. It muddies the waters because it didn't actually look to any Texas peer review-related case law in making that decision. The standard that it does use is the standard from the Luce case, which involved a car repo. And that's the common law definition of malice. So here, the Pucciarotti court, because it didn't look to any of the Texas peer review related case law, and again, they're kind of excused for that. No one pointed them to that case law. They pluck this other new malice standard out and use it. And I'd also note that in the Pucciarotti case, they never really looked at malice in terms of the Texas Medical Practice Act and immunity. They analyzed malice with respect to the malicious prosecution claim. And then they noted kind of towards the end of the opinion, yeah, there's been a TMPA defense, but we already found malice with respect to malicious prosecution. We don't need to look at it again. And again, this was all because they were making this decision in that vacuum. Now, our brief is distinct. It relies primarily on nearly 50 years worth of Texas peer review related case law. And I'd like to talk about that case law a little bit. Now, as noted by Justice John Cornyn in another negligent credentialing case where a patient sued a hospital, fearing litigation, some hospitals would trade their silence about a physician's reasons for leaving for the physician's voluntary resignation, leaving the physician free to continue to practice medicine despite a record of incompetence. Now, this is a balancing act that occurred back in the 1970s and 80s, arising out of the adoption of tort reform with respect to medical malpractice cases. The Texas legislature adopted 4590I, which is now Chapter 74 of the Texas Civil Practice and Remedies Code. And just 4 years later, they adopted an immunity statute or incorporated this into the Texas Medical Practice Act. And this preceded HCQA, or the Healthcare Quality Improvement Act, which is the federal immunity that goes to peer review related cases. The reason the Texas legislature adopted this immunity was to ensure that where patients weren't able to sue doctors quite so easily when they committed malpractice, that doctors would be able to police doctors through the peer review process. Since that time, and even prior to the adoption of the TMPA immunity, there was case law supportive of a peer review related immunity of sorts. And this pre-1981 case law has even been incorporated by the post-1981 case law. The pre-1981 case law said there's just no cause of action whatsoever for a physician bringing an action against a private hospital for decisions impacting their privileges. And that has been incorporated in some of the post-1980 case law. Post-1980, that was, or 1981, that was the creation of this malice standard, where we get this competing question of, are we going with the exemplary damages definition of malice, or are we going with the Maywall standard of malice? And again, whichever definition the court wants to go with, I think I'm all right with, but we know that it's one of those two definitions and not the one used in Pichiroti. Now, I did want to point out a couple of issues from appellant's argument. I heard him say that it was undisputed that the medical executive board did not consider the inappropriate incursions into the medical record. However, the trial court record reflects that it's not undisputed. We had Dr. Mohan testify that the MEB did take this up. We had the PowerPoint presentation from that MEB meeting that specifically noted the numbers associated with these concerns that Dr. Vishal made hundreds of inappropriate incursions into the medical record.
If that were the case, shouldn't Dr. Vishal been afforded an opportunity to respond to that?
Well, he was at the fair hearing panel.
But at the MEB stage?
So the bylaws allow for amendments to the statement of charges after the MEB level or in anticipation of the fair hearing. As I heard appellant's counsel say that the hospital charged ahead with this revocation, that's not exactly true. Dr. Vishal exercised his due process rights and he sought a fair hearing. Sure.
If the MEB considered that, that wasn't one of the allegations or one of the findings, right? They didn't find that he had violated any HIPAA.
Well, the MEB itself, I'm sorry.
Go ahead.
The MEB itself, when they sent the letter to Dr. Vishal, noted concerns associated with patient care, with documentation, but it did not delineate with significant specificity all of the things that it had considered. What we do know is that it was considered, and ultimately, and I believe even Dr. Mohan testified that they were more concerned about the patient care issues, the prior MPDB report that looked a lot like some of the 38 separate MIDA reports that they had considered. There were things that concerned the MEB more perhaps than it did the fair hearing panel. But, you know, as noted, courts and panels and committees like this, they might find different things valuable. This is why it's important that the judiciary can't be used to substitute the judgment of these peer review bodies.
Do you agree that the fair hearing panel's decision was based only on the access issue?
I would, in my reading of the fair hearing panel's decision, they seem to find that, you know, maybe some of Dr. Vishal's conduct was excusable, and then they predominantly rested their decision on the inappropriate incursions into the medical record. Yes.
So if that's the case, you would find that he was exonerated on those other three allegations?
I wouldn't say that he was exonerated. If in reading the fair hearing panel's decision, the fair hearing panel seems to acknowledge throughout that there were miscommunications, that there were issues that were noted by the MEB, and then they focus on the hospital's behavior. They don't say he didn't do any of these things. What they say is, these things happened and the hospital may have borne some responsibility to have clearer policies.
What did the hospital do to controvert Dr. Vishal's explanation for those charts? You know, he gave an explanation, and part of the explanation for some of those that, I think for the very few out of the 800 plus, he said there was some confusion. There were no real clear hospital policies on assigning patients and things of that sort. So what evidence did the hospital put forth to controvert?
Sure. With respect to the incursions into the charts, the issue that the hospital considered to be an issue wasn't whether or not it was appropriate under HIPAA for him to be in those charts, but whether it was appropriate for him to be in those charts under hospital policy. In order to get into those charts, he had to click and say that he was treating this patient, and in effect, he wasn't treating hundreds of patients, he was treating tens of patients. This is consequential because the hospital itself has to adhere to HIPAA, and that includes having technical, administrative, and physical safeguards that ensure that they kind of know who's in the charts for what reason. And the behavior of going into these charts for his own business purposes, even if they were appropriate under HIPAA, subverted the hospital's ability to ensure that their medical record was secure.
Do you agree that there is a malicious prosecution claim or a malicious review claim?
I don't. I don't think that the appellants in this case have adequately demonstrated the elements of this cause of action.
Do you agree that one exists, you just don't believe they meet the standard?
I believe that the only case that would support that this cause of action exists is Pisciarodi, which again did not consider the Texas peer review specific case law that in many instances has said that there's no cause of action against a peer review body for matters affecting privileges. So I'm not sure that I would agree that there's even a cause of action. And even if you look at the Luce case, which was cited for the definition of malice in Pisciarodi, it says that malicious prosecution claims are not looked well upon by the courts. I don't think that a malicious prosecution claim necessarily exists for peer review matters.
Does the Occupation Code 160.010 imply that there is? Subsection B says a cause of action does not accrue against a member, agent, or employee of a medical peer review committee or against a healthcare entity, without malice. So if you show malice, is there a cause of action?
So what I would argue is that 160.010, which incorporates the entirety of HICWA into it, by the way, it's an additive issue. In order to have a case against a peer review body that would otherwise be immune, you have to show that they did not come up to HICWA standards and also malice and also the underlying cause of action.
So there has to be an independent peer review cause of action plus malice, like a super tort.
Yes.
Right. But why then have this if there isn't a cause of action for malicious peer review?
Why then have what? I'm sorry.
Why then have to add the malice if this tort doesn't exist?
Because the 160.010 doesn't independently create a private right of action. Just like HICWA, which it has been determined does not create a private right of action, I would argue that the case law bears out that the TMPA does not independently create a private right of action. It must be something grounded in something else that you then add. Oh, sure.
Recognize malicious credentialing. That's just the other end of the spectrum of a review board's role, right? So why would it be okay why does it make sense to create a cause of action for malicious credentialing but not have malicious review?
To that, I can't speak to. I didn't dive too deep into malicious credentialing cases except to the extent that they spoke to malicious peer review. I would note that the malicious credentialing claim, to the extent that it was created, has never been successfully pursued under the Texas Supreme Court's rulings on this issue.
They haven't been able to show malice.
Correct. It's a high standard.
How do you address the point that the burden of proof was shifted?
So the cases cited associated with the burden of proof issue primarily were related to the pleading rules associated with contracts cases and whose job it is to show conditions precedent. Again, nothing to do with the peer review process whatsoever. There's only one burden of proof in this hospital's bylaws. And that burden of proof is the one that's applied to the fair hearing panel. It goes to whether or not the action taken was appropriate by the MEB, not whether they found appropriately with respect to some sort of cause of action or charge, but whether the action taken by the MEB was appropriate. So there was no other appropriate burden of proof to apply. There was only ever one burden of proof. When Dr. Vishal took advantage of his due process rights and appealed this decision to the fair hearing panel, it was on them to determine whether or not it was appropriate for his privileges to be revoked, not the underlying reasons therefore.
What about, let's go to Mr. Thomas's, when I asked what evidence he had for malice, he listed off 5 things, and he's clearly bringing circumstantial evidence to come together to do this. And not only the competitors on the board, That's not just the existence of a conflict, but the fact that they flipped the burden, they brought forth claims at a higher level without giving him opportunity to respond, and the fair hearing panel sounds like it went back on its decision in terms of only relying upon the fourth allegation. Why does that not come together to create at least some evidence of malice?
Sure. Well, first I'd address with respect to the burden of proof, it would be exceedingly difficult to show that a hospital acted maliciously in following its own bylaws. There was a hearing officer whose job it was to help ensure that Dr. Vishal got due process, and my understanding is he did a good job of that. And part of that was holding the hospital to its bylaws with respect to the fair hearing process, giving him that opportunity to be heard in ways that the MEB is not necessarily going to have the ability or capacity to do. So it would be difficult to show malice when the hospital is following its own bylaws under HCWA as appropriate. With respect to this economic competition issue, I'd like to turn back to the trial court version of Polliner, which was cited by appellants in this case. They specifically considered a similar allegation of economic competition.
Which case? I'm sorry.
It was the trial court version of Polliner, yes.
Less than 2 minutes.
Sure. And at this trial court level version of Polliner, they had an ad hoc committee, which was substantially similar to our MEB. This ad hoc committee had 6 members. They alleged that 3 of those members were in groups that were in economic competition with the appellate. Now, the trial court and Polliner found that that was not sufficient. They asked the obvious question, what about the other 3 people on the panel? What motive did they have? How was their choice to suspend Dr. Polliner's privileges malicious? Now, in the present case, we had 17 people at this MEB meeting. Appellant in this case has only claimed that 3 of them were associated with a competing hospitalist group. Of those, one of those 3 was a non-voting member. This court has even more reason to ask, what about the other 14 members of the panel? Why would they have voted to revoke? There's no evidence of malice. There's no allegations of malice with respect to the vast majority of the people on the MEB. And in considering this, the Polliner court found that there was not legally sufficient evidence of malice. The only other point that I will very briefly get to is that this court has been asked to review this case and can affirm the trial court's decision on any basis supported by the record. And I think that there are multiple bases supported by this record, with the trial court judge as the fact finder and the sole judge of the credibility of the evidence here. There is no cause of action. There is no real showing to rebut immunity here. And the trial court judge could have easily found both of those things. And they could similarly have found that there was no probable right to the relief sought. Thank you.
Thank you. Mr. Thomas? Come up.
May it please the court. I'm going to probably jump around a little bit to try to address a bunch of different points that Ms. Hobbs raised, but I want to start with the burden of proof argument. She said that there's only one burden of proof in the bylaws. That's not true. It contemplates that the burden of proof is on the provider at the fair hearing level, but at the MEB level, the burden is on the hospital. The MEB doesn't even have to talk to the provider at the MEB level. They have to.
Because he didn't even address it below, he didn't have the opportunity, he never had the requirement to meet that burden.
Right, they never even talked to him, but even if they had followed their own bylaws to go to the MEB with that allegation, with that 4th allegation regarding improper access, they weren't obligated to talk to him as part of their investigation. Their job was just to investigate, and after investigating, if they sustained that allegation, so their burden to sustain, and they made a determination that he should be suspended for more than 29 days, only then does it go to the fair hearing level. It's undisputed that there was never such a finding in this case, so why are we at the fair hearing level on this allegation at all?
So, but let's go back, because the flipping the burden, the new allegations, the unsupported, all that is the circumstantial evidence you're building around the idea that you had competitors on the MEB. But I think she has a good point. I want you to address it. If there's only 3 of the 17 that were competitors, and there's 14 others, actually, without taking the one out that was not a non-voting member, you had 15 that were not subject to a conflict or competitor, then why is the circumstantial evidence even relevant? Because you haven't sued the individual competitors, you've sued the hospital, the board, right?
Well, we actually have sued the individual competitors as well. The only reason that the hospital is the only appellee is because they're the ones that would report to the National Practitioner Data Bank.
Right, but you have to attack the finding of the board, right? And if you've only got 2 of the 17 that could have even potentially acted in furtherance of a conflict, which means they didn't determine the vote, why is it relevant that you have all this other circumstantial evidence?
Well, I think, one bad apple can spoil the bunch. This is, the MEB meets as a group and they discuss these things and they decide what to do. So if you have 3 people that have a vested interest in kicking him out of the hospital because they're his direct competitor, and by the way, the main issue before the MEB, the main allegation was that he was improperly poaching patients. All of these guys are hospitalists and they're fighting for patients at the hospital. And one of the main allegation was that he was poaching patients from the ER against hospital policy.
Well,
so this is something.
He wasn't rounding, and that he was contacting patients that he wasn't a PCP for. And if we read the comments of the other 14, they're not really heavy on the competition issue. They're heavy on the rounding and was he appropriately caring for patients, and was he trying to get patients by saying he was a PCP when he wasn't, correct?
Well, I'm not sure that we know what the other 14 were thinking. We don't have access to the minutes from that meeting.
But it has the findings in one of the exhibits.
Sure. But I think the primary allegation of the 3 was the poaching of patients, which is something that those competitors had a vested interest in. So they're deciding something about him that they have a vested interest in.
But what I'm trying to get you to do is to understand there's 14 others, and they had individual votes, and we have the basis for their vote. So why does it matter if a very small number in the minority has a competition conflict? How does that impact the finding of the others?
Well, I think this whole process is supposed to be fair, right? And I think if you allow direct competitors to be on the board, I think it's per se not fair. And I think the fact that they have so many people on the MEB makes it clear that they easily could have convened without these 3 competitors. The 3 could have just recused themselves, and the other 14 could have met by themselves.
Can you address Ms. Hobbs' statement about Polliner in that regard?
What specifically, I'm sorry?
She said that Polliner actually addressed the issue about the fact that there is a minority with a competitive issue.
I apologize, it's not ringing a bell, but yeah,
You mentioned something in your briefing, I believe, where the process wasn't anonymous. Can you explain that very briefly?
Yes. So they, another argument that they make is that, that the fact that these competitors were on the MEB is irrelevant because Dr. Vishal was presented to them anonymously, so they didn't know who he was. But I think that's false. We pointed out, there's things in the record that identify him by name, or talk about, his group, Alamo Physicians Group, which is a direct competitor to Envision, where the competitors were employed. So their own records indicate that that's not exactly true. He was not presented anonymously. Going back to malice for a second, I think one thing that we haven't talked about is, there's a lot of case law, Pisciarati and multiple other cases that talk about how malice can be inferred from a lack of probable cause. And I think we absolutely have a lack of probable cause here. Again, the fair hearing panel specifically found that all 3 grounds for the MEB's decision were, quote, not supported, that revocation was not an appropriate remedy, and that he should be reinstated immediately. So, you've got that, and you've also, one other thing that we haven't talked about yet is that, as I mentioned, one of the, in my view, the primary allegation at the MEB level was that he was failing to follow hospital policies regarding assignment of patients from the ER to hospitalists. And the Fair Hearing Panel specifically found that those policies don't exist. So they revoked his privileges based on policies that don't exist. That is a lack of probable cause from which you can infer malice. That is at least some evidence of both lack of probable cause and malice. Ms. Hobbs argues that,
Let me stop you there for a minute,
Yes.
Mr. Thomas. So wouldn't we then be looking at the HIPAA violation allegations if we were to say, to agree with what you just said? Because there were no policies on the assignment of patients in the ER. Did that have something to do with that fourth allegation? Did it not?
no, two
Okay.
separate issues. So
Okay.
the policies have to do with what I call poaching patients. Basically they're arguing that he's stealing patients that should have been assigned to them instead of to him or to his group, according to hospital policies. And the Fair Hearing Panel found, well, what policies are you talking about? They don't exist. The HIPAA violation is something completely different. They're alleging that he improperly accessed patient records that he did not have a right to access.
But they were alleging that he did that in trying to get patients steered to him, so it goes back to the original issue, that he was going into patients, he was changing the PCP so that he could have access to it, to see who was treating him, and then he would take his name off of it and get out of it. So it goes back to the original allegation, right?
Well, I mean, yes and no. I think my reading of the allegation is that, what they're taking issue with is that he's basically invading the patient's privacy. That's what they're taking issue with. He doesn't have a right to access patient records. These are private. It's a HIPAA issue. And, Ms. Hobbs talked about, well, it's not HIPAA, it's hospital policy. But if you look at the Fair Hearing Panel's report, they specifically refer to it as the HIPAA allegations. So I think HIPAA does come into play here, and not just hospital policy. Ms. Hobbs argued that that there was evidence in the record that the medical executive board considered that fourth allegation regarding improper patient access, improper patient record access, but their own Fair Hearing Panel report says otherwise. They specifically find that that's not true. That it was never considered at the MEB level. And I think you don't have to look any further than their revocation letter, which is in the record, where they list out the grounds for his revocation. It's 3 things, and none of those 3 things has anything to do with improperly accessing patient records. But if she's right, if they did consider that allegation at the MEB level, then I think they've really got a problem, because they obviously didn't sustain that allegation because it wasn't in the revocation letter, right? And so if they didn't sustain it, it should have stopped there. It never should have gone to the next level. It should have ended. Their bylaws specifically talk about that. If the MEB doesn't sustain an allegation, it's over, period.
Again, but then there's no appeal of a revocation of privileges. That's specifically 160.010. There's no appeal if they got it wrong. There's only an appeal if they did it with an intent of malice, right? So the fact that they may have gotten it wrong is not necessarily proof of malice.
True. Not by itself, but, again, we go back to this, circumstantial evidence. I think you've just got so many different things going on here with this peer review that I think there's at least some evidence that merits entering a temporary injunction, hitting pause on this career-damaging report, and let us flesh out the issues. We haven't even taken discovery yet. We've got all of this without any discovery. So hit pause. Don't ruin the guy's career. It's no skin off the hospital's nose to pause this report for several months or even a year. They've waited this long to report him. It's already been, multiple years. Why do they need to rush to the MPDB now?
Your time is up, Mr. Thomas.
Thank you all very much.
And thank you very much. Didn't mean to cut you off.
Okay.
The case is submitted. You will be notified as soon as we have an opinion. Thank you very much. Court is adjourned.